rather than the reverse. At the end of 5 years, you come here with great confidence and great eloquence, and at the end of 5 years, if you end up losing that, then that's going to be a huge loss. It will not happen with all these um, teachers to support you, but we want to see some of that. Now, please speak or ask any questions you want, and primarily, faculty or students, but let's give students the first preference. Constitutional law. That's my core interest and core field. And I'll just say this in 2-3 minutes. I think the Constitution is phrased, its preamble is phrased in a way no other constitution in the world is phrased. It says, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens," and then it goes on, right? Now, what is remarkable and unique about this is the first phrase, "We the people of India." In many other constitutions, they say, "We the people of India hereby constitute India into a sovereign, socialist, democratic republic, and to secure to all its citizens, so and so, and we hereby adopt the Constitution." But what is unique about the Indian Constitution is we the people do not say that. We the people say, "We the people have solemnly resolved to constitute India." The word constitute means create. Create. Constitute a committee means create a committee. Constitute something means take something else and make it into something. So we the people of India declaring that they have decided to make a new India. As a sovereign, socialist, secular, democratic republic, and to secure, we have resolved to secure to all its citizens. So I say the Constitution of India preamble is a declaration by the people of India of the continuation, not just the commencement, the continuation of a historic struggle to create a new India. Because if the India they are conceiving already exists now or existed in the past, there is no need to say we have resolved to constitute India. And Article 1 reference to India that is Bharat is to this new India. India that is Bharat, not Bharat that is India. Which India? The India that we are going to constitute. We have resolved to constitute. So it's a constitution so I therefore say that I theorize the constitution of India as a site of revolutionary struggle. The revolution for creating a sovereign, socialist, secular, democratic India, which does not exist, which has been fought for centuries in all kinds of ways, is now going to be fought not exclusively, but also in this constitution. So Dr. Ambedkar saw this as a means of creating a space where this constitutional space for the struggle to occur, which is why in his last speech he says, "Now don't fight on the street, fight inside the Constitution." Because he's created a space for us to engage in this historic struggle to constitute a democratic society inside the state. And that's the magic of this constitution. It's a site of struggle. And it gives a number of instruments and weapons for us to take the struggle forward. But also, because it's a compromise of different forces, there are other forces that have also put their weapons on this battlefield. This battlefield has weapons of those who are fighting for democracy, and it has weapons of those who are fighting against democracy, like preventive detention, so on and so forth. They're all there in this battle, like any other battlefield. You have weapons of both sides, armies of both sides on this battlefield called the Constitution of India. And so when you say when you see the title, the Constitution of India, we can read it as the creation of India. This is the framework of the battlefield in which the battle is being fought for the creation of India. I've written, the Hindu has published an e-book called Constitution Debates. And in that e-book, I've written a chapter called Ambedkar's Preamble, which gives you a detail of how Ambedkar rejected the draft preamble, 35-word preamble drafted by Benaga Narasimha Rao, and produced his own draft of the preamble. And what we have today, with some modifications, is Dr. Ambedkar's draft of the preamble. That is the draft which says, we the people of India have solemnly are hereby solemnly resolving, have resolved to create India. That is his language. And I've given detailed sort of evidence of that, going through the history of the preamble. So if you are interested to read it, you can read it. So we must understand, in the long arc of history, we are living at a time when there is a massive struggle going on in the subcontinent to constitute a democratic society and a democratic polity, which has never existed. Dr. Ambedkar says in Buddhist times it existed, but since then it has never existed on this subcontinent. And you as lawyers, you can either choose to be on the side against creating such a democratic order. We don't have it. We are not living in a democracy. We are not living in a democratic society, but we are living in the midst of a constitutional struggle to create a democratic order. And you can choose to be on one side or the other side. As law students, fight against the democratization of Indian society or for the democratization of Indian society. That's a struggle that we're going on. That's a struggle that I work on. So let me stop here, otherwise I will consume all the time. Now we still have about an hour left. So
I'm currently enrolled in the LLM program.
So what's your name, sir?
Rishik.
R-I?
S-H-I-K.
Okay.
So you mentioned about, you write about the democratic decline in India. So I want to point out a criticism within the Indian Constitution. Gautam Bhatia has said that it is because there are certain design flaws in the Indian Constitution, especially with regard to Parliament. In the Constitution, to Parliament. Yeah, there are no mechanisms, especially to hold the government accountable within Parliament, and also the Speaker. He's appointed by the ruling party, and also the defection law, which actually prohibits members of Parliament to actually it actually curtails their freedom in many ways. So, how do you see, especially, do you see that the Indian Constitution had a centralizing tendency, and therefore, compared to say UK, the Parliament in India is actually pretty toothless, because even if you want to hold the government to power, it actually depends on the willingness of the majority to subject themselves to power, and opposition does not really have any rights, so to speak.
Very good question. Look at the Constitution, like you look at the American Constitution, which is now America's Declaration of Independence is now 250 years old. Its Constitution was in 1776, right? Lasted over 2 centuries. Or other written constitution, Australian constitution, and so on. Then we might ask, was there a design flaw? And that's very plausible, and there's nothing wrong with that. But if you look at it as I do, that what Ambedkar realized is that there has been a long-standing struggle for democratization in the, waged by common people for a democratic society. What is democracy? Democracy can be best understood by etymologically by two words: demos and kratos. Kratos means power, demos means common people. So democracy is a condition in which power is in the hands of common people. So if Ambedkar said, look, the objective is to create space to take forward this democratic struggle. And so, given that India had become independent, he knew that what was possible in the Constituent Assembly, which was heavily dominated by uh, old, patriarchal, males, rich, feudal people who were smacking their lips that the British had left, now we get to rule this land and dominate all its people and all its women and all its excluded, marginalized groups now without any let of hindrance. Right? He knew that it was not realistic to sit there. He didn't have the design freedom to say, look, let me fine-tune this to make it a federal republic, pure federal, decentralized republic, and so on. Plus, Dr. Ambedkar was concerned that if you decentralize too much, then he said in 1930 to the Roundtable Conference that India would be ruled by oligarchy after the British leave. Oligarchy means monarchy means one person's rule. Oligarchy means oligos means few people. Oligarchy means few people's rule. So he knew very well that India was heading into an oligarchy. And he knows that the seat of this oligarchy is in the local, in diverse ways, in local areas all across the country, including, for example, in Travancore, where I come from. I was actually born in the United States of Travancore, Cochin, as it was, between 1946 and 1956, in that period when Kerala was formed in 56. So he knew that that was ruled by Maharaja, and Travancore was actually self-declared a Hindu state. So he did not want to give all the power down to the Hindu states and Hindu Rashtras and feudal monarchs and oligarchs and so on and so forth. He was aware very closely of the American example where the federal government had strong federal, initially intended to be a very weak federal government, but grew to be stronger and used the United States Constitution as with all the states. We were supposed to have that to having state constitutions in order to bring about progressive change, civil rights change by using the interstate commerce clause and saying, okay, we can enforce civil rights in states using the federal government against states which were very conservative and would not give equality and so on and so forth. So, given all that experience, Dr. Ambedkar did want to have a democratic union parliament based on one person, one vote that would drive progressive democratization in the subcontinent. But he did not know whether that would happen, if it would happen, when it would happen. But he just put some broad structures for democratization to happen. Right? So he put. He created firstly, he insisted on one person, one vote, universal adult franchise. He created separation of powers. He created legislature, executive, and judiciary. He created 3 lists, not he himself, but he very knowingly, when there was, I've spoken to you before on this, there was no one as learned as Ambedkar in the whole country or in the Constituent Assembly. He understood, he knew what he was doing. He created these separate lists, state list, union list, concurrent list. And he did not address the question of federalism too explicitly, because he could not. He went as far as possible. Nor was he in favor of strong decentralization because of reasons I had explained, the Constitution. I've written an article in the book written by Muralidhar, Justice Muralidhar, edited by Justice Muralidhar on 75 years of the Constitution, Incomplete Justice, ? I've written a chapter on, at his request, on Supreme Court and caste. And there Supreme Court is approached caste. Knowing very well that a lot of space is given to the anti-democratic forces where he had no choice, not by choice, but he could not push back more. And so it's like any battlefield. right? You don't choose the battlefield. The enemy also chooses the battlefield. You also choose the battlefield. You can't tell the enemy, this is the battlefield, I'll fight you here. You fight the enemy where you meet the enemy, right? And then you create the opportunities in the battlefield. He's created those opportunities. Now, actually, a situation has come where in some parts of the country, like, for example, in my state in Kerala, the grassroots have become extremely democratic in its political approach and political consciousness. Um, in some other parts of the country, the grassroots are still highly influenced by anti-democratic ideas. So we can't take, in my view, a very simplistic approach to the struggle for democratic transformation. So it's a very complex issue, which I think we can't sort of deal with in a simplistic manner. Let me say here one other central proposition I have, which is there's only one socio-political crisis this country faces, which is an existential crisis for the Indian Republic. And that crisis is the challenge of democratizing the Hindu social order. That is the crisis. The other social groups do not have a theology and a deeply practiced and set of belief systems regarding inequality of communities, of gender, various kinds of grade of inequality based on, which are justified in religious terms, based on previous births and carry over from good and bad actions from the previous births. A very complex, deep-seated ideology of inequality at all levels. We have 5 different ways of saying YOU. At least, if not only, a lot of these people, about 15 or 20 of these people were born in the 20th century. The last of these people to be born was B.R. Ambedkar in 1891. And when he said in 1936, annihilate caste, he said it on behalf of this entire century of struggle, annihilate caste. And democratize the Hindu social order. Can the Hindus not have a social order in which everyone believes that everyone is Homo sapiens and is inherently born equal, regardless of gender, caste, community, region, color, appearance? We are all endowed with the same human qualities and potential. Then we will live in that. In order to stop this, there's an attack on democracy. Because if democracy prevails, then this Hindu social order cannot survive. The greatest threat faced by this Hindu social order is the idea of democracy. And in order to stop democracy, we are creating all kinds of artificial fights, making the Muslim the enemy, the foreigner the enemy, xenophobia, all kinds of things. In order basically to prevent the Hindu social order from becoming democratic and to maintain what Ambedkar called the oligarchic rule of the Hindu social order. So it's a very complex situation, and I don't think we can understand the constitutional law behind it, in isolation from this struggle that we are going through, which I don't think any other populace has actually faced in this manner that we're facing. Sorry for the long answer, but it's a very the struggle for democracy is very complex in our country, everywhere, but especially here. Yes, sir. Made some nice comments, very good comments to the Honorable Chief Justice, which she also appreciated very much. Yeah.
Good evening, sir. I am Manya. I am a first year, 5-year LLB law student. So,
First year?
LLB law student.
Okay.
So, we take a lot of pride whenever our leaders go out and say, we are the biggest democracy in the world.
Yes.
But still, when you said that we are still on the journey of having that true democratization of a society and a nation, how does it look? The true democracy, how does it look? And when the fight will be over, what we will do as lawyers then?
Okay. That doesn't make us the largest democracy in the world. And if you're interested to know more about what is the way of understanding and measuring and defining democracy, there is a University of Gothenburg in Sweden, Gothenburg, institute in Sweden, which has an institute which studies democracy in great depth called VDEM, Varieties of Democracy Institute. There they look at over 200 countries, over 200 years, they've got lots of data and statistics, and they say there are the following types of political systems. One is they have a liberal democracy, and they have an electoral democracy, and then they have a electoral autocracy and a full-fledged autocracy, four broad categories. A liberal democracy is one where there is economic democracy, social democracy, there is participatory decision making, there is accountability, there is voice, there is decentralization, there is people's voice in decision making very deep. For example, the United States, 97% of judges are elected in an election. Most police chiefs are elected in an election. Everything here we are going to one person, one vote. There is several elections a day, every day of the year, 365 days in the year, constant elections. The equivalent of Lok Sabha is the House of Representatives. They are elected for 2 years, not for 5 years. And so we find that in the most economically advanced countries, there's constant elections. And then you go to the other extreme of great poverty and hunger and suffering, according to what we know, the information is completely closed. North Korea, there's no election at all. So when we say one nation, one election, we're very close to the North Korean end of the spectrum, and not very far away from the other end of the spectrum, where we have elections constantly. There they do not see elections as a waste of money or a waste of time, but as a necessary instrument to ensure that people's voice inform the running of the state. And so democracy is a continuous process. It's not a destination, it's a process. It's a process of ensuring that power, Kratos, is in the hands of people, demos. And constantly the people must demand, no, but I was not consulted, I was not told. It is not a question of abdicating power to a small oligarchy or a small elite. You decide and guide us, you're wise people, you're clever people, and you know what to do, and we will just follow and obey you. Right? That's not a democracy. So, first of all, if we want to graduate from being, and of course, there's economic democracy, where there's economic equality and distribution of wealth and resources. In fact, if you want to find a good definition of what India will look like when it is a full democracy, read the directive principles of state policy. Material resources of the community are so distributed as to best serve the common good. Not only individuals, but there's equality amongst the individuals, but also amongst groups. There is equality. Look at the equality of women, condition of children, condition of workers. All this is in the directive principles of state policy. That's kind of gives you a sense of what we will look like when we reach a condition where power is in the hands of people. When power is in the hands of people, they will ensure, however weak and weak they are, or powerless they are, that power will be exercised by them, and when they do that, they will ensure that their interests are looked after. Right? So we have to create economic democracy, decision-making democracy, social democracy. We have to annihilate caste. We have to annihilate patriarchy and gender differences, prejudices of all kinds, and then we'll start to slowly recognize that we are all just Homo sapiens, different, one species. Then we'll start. Now, what will be the role of the lawyer? To safeguard this democracy. Because we know from history that when this happens, there will always be a group of people who will try to capture power, push out others away from power and concentrate power in themselves by creating a false enemy, by invoking religion, by invoking patriotism, xenophobia, patriarchy, all kinds of justifications and reasons to make us afraid that unless we hand over power to them, we are in trouble. And by handing over power to them, our situation will emerge. So what's the role of the lawyer? Ultimately, in the modern system, in the ancient times, there were no lawyers, no law schools, no lawyers. The law was what the king said it was, and the king and his people enforced the law as they pleased, right? But the modern legal system, we have developed a system where the role of the lawyer is to ensure that there is justified restraint on power. Justified by the interests of the common people. So our job as lawyers is to restrain power, not to enable power. And that's always going to be a challenge, whether at the micro level, inside a family, inside a community, in a neighborhood, in an institution. There will always be an effort to assert power. And there are justified limitations on power. Legitimate, rational, justified limitations on power. But there must be norms to clearly articulate, democratically set norms on when power can be when power can be denied to people, when people's freedom and liberty can be taken away, right? So when such instances happen of the powerful asserting their power over the powerless and taking away their power, then it is up to lawyers to ensure that the limits prescribed for justified exercise of power over others are not exceeded. That's your core. That's everything you study here will have to do only with one thing: is human conduct right or wrong? That's all law is interested in. And right or wrong, not in a religious or moral sense of the word, but to ensure that democracy is upheld, that people are free and equal and have liberty. If we are not doing that, if we are simply enabling power, then frankly there's no point in having all this, because without any of this legal education, the powerful ruled countries with Danda and army, there was no need for anyone to be educated to enable powerful people to rule the country, because as is famously said, the law has neither purse nor sword. We don't control money, we don't control violence. So why are we there? We are there to restrain the purse and restrain the sword. Does that answer your question a little bit? Okay.
Yes, you have time. If I have two questions, if
sure,
you permit me.
Certainly.
So the first question I have is, as you have pointed out, under Article 326 of our Constitution, we have ensured that there is universal adult franchise.
Yes.
But sir, in reference to a very recent case that has happened,
yes,
namely Association for Democratic Reforms is the Union of India, and in reference,
I think that was a better mic. That mic was better.
And multiple cases from NP Ponuswamy, Jyoti Basu, TUCL, Kuldeep Nair, in all these cases, except for Arup Baranwal, one judgment by Justice Ajay Rastogi, is HMJ as he was. The principle that they have said is, voting is not a fundamental right.
Yeah.
And Justice Chandrachud himself, who was a dissenting opinion in the Keshwananda Bharati case, right, in the
Senior Chandrachud,
yes, as he then was, in his famous judgment in the election case, he said the reason why I am striking down the amendment is because democracy is getting affected. Whereas all the courts have declared it no longer res integra, that voting is not a fundamental right, and it's only a statutory or a constitutional right, not even a common law right. But we have said that democracy is part of basic structure. Isn't it a contradiction in itself? Because though we have given universal adult franchise, like in the US, there is voter restrainment. here also there is a chance of voter restrainment, and in the recent judgment of the Supreme Court itself, some doubts are cast. And after that, the second question itself, it's a question that is very dear to me, about the directive principles of state policy. Professor K.T. Shah, in his Constituent Assembly debates, called it a sham. Whatever happened was a complete sham. All the, all the insurgent, some of the insurgent groups that say, I mean, one of the earliest criticisms of the Constitution itself was that all the things of social democracy or all the social changes that had to be made have been relegated into non-enforceable DPSP, and rights like the right to property itself was included inside fundamental rights, which in itself in the Jyotirao Sindhya, Madhavarao Sindhya case, they held it to be, the judgment that also happened. They used Article 31 to justify the reversal of the Privy Purses order. And so, sir, and even Sirva himself in his third volume says that it's useless. DPSP are useless. It's only after Justice Chenappa Reddy in the Ranveer Singh case, who included right to work, a little bit thing has been done. But even undoing of that also has been done in the Property Owners Association case. So, what is your comment on both?
I guess Maharashtra
Property Owners Association case, with 3 dissents by 3 learned judges, but the majority held something that they have completely reversed Sri Ranganath Reddy versus State of Karnataka by Krishna Iyer, Justice Krishna Iyer, as it
and of course they attacked Krishna Iyer also in that judgment.
with very serious comments.
Which Justice Nagar.
And there was also a very recent attack on day before yesterday, I believe, was the recent attack on Krishna Iyer that again happened. So, what are your comments on these?
Well, first of all, I want to really admire your incredible mastery over law and case law and clarity. What's your name, sir?
My name is Krishna Vijay Palaku, sir. I'm a 4th year student of law.
Krishna Vijay Palaku.
Krishna Vijay, sir. My name is Krishna Vijay.
Okay, Krishna. Very, very wonderful exposition. I'm really impressed by your passion and your interest and your knowledge of all these judgments. And yes, wonderful. I'm not surprised, and I'm sure we will hear a lot about of Krishna in the years to come, which I look forward to. I may not be around then, but remember me. Yes, share this podcast by a professor of mathematics who was interviewing a Nobel Prize winner in quantum physics just very recently, and the Nobel Prize winner quantum physics said to this MIT math professor that you remember many years ago, and this is not exactly how he said it, I'm just making it short. You remember many years ago teaching, when you were a young professor, teaching a first year undergraduate math class. I was an undergraduate student in that class. And he said, I was sitting there and I had a question in my mind, and suddenly you focused on me, a very large class, you focused on me, addressed me by my name, Adam, and said, Adam, you look like you're not very comfortable with what I'm saying, or there's something troubling you. He said, yes, and he answered that, he said, this is what is troubling me. And he said, I came to MIT and it was overwhelming for me. All these big courses and all that, big professors. No other professor except you recognized, without my saying anything, understood that I was troubled by something, knew my name and addressed me by name. So I want to thank you for this, what an influence you had on me. But this guy said, look, this is the first time I've had a student in my class, undergraduate student, who I'm now interviewing in a podcast as a Nobel Prize winner. Right? So he did, the student sitting there was a future Nobel Prize winner. I think, Krishna, I want to recognize you because I think one day you will be like that. Anyway, coming back to the question, I basically totally agree with you that let me give you a sociological explanation. The judiciary is dominated by the oligarchy. If we look at the long arc of time, there has never been, I'm not saying this is therefore the jurisprudence would have been different, I'm not saying that, but just to give an insight, has there ever been a Supreme Court judge with the last name Yadav?
Said by you in the Hindu interview.
Yes,
also, sir.
yes, yeah. So the oligarchy, there's nothing Krishna misses. So the oligarchy, four communities, from four communities, that doesn't mean individuals are prejudiced or oligarchic or anything like that. But we're all, as Justice Cardozo wrote in The Nature of the Judicial Process, we are all carried by the times in which we live, and judges are no exception. So naturally, in this, if the seminal battle in our country now is between democratizing the Hindu social order and not democratizing the Hindu social order, maintaining the oligarchy, then we are not surprised that a number of judgments, I'm not talking judges, number of judgments reflect a kind of little bit of an allergy to taking democracy to its fullest extent. And I can find no other rationale for the Supreme Court not strongly asserting that the right to vote is a fundamental right. It is a fundamental right. I have no doubt. See, one thing we must realize is that we must have our own view of the Constitution. We understand that the Supreme Court judgment is binding on all the courts of the country. If you take what the Constitution says, the law laid down by the Supreme Court shall be binding on all the courts of the country, not all the people of the country, but all the courts of the country and the state. But we must each have our own view of the Constitution, of what is right and what is wrong in the Constitution, against which we must judge the Supreme Court. And when the Supreme Court is wrong, we must question it. Question the judgment saying, I think it is wrong. Don't accept the view of the Supreme Court as the right view of the Constitution. It is the court's view of the Constitution, which is lawful, legitimate, it's exposition of the Supreme Court binding on all the authorities of the state. We accept that, we don't question that. But that doesn't mean I have to believe that they're right. And the Supreme Court has never denied us that freedom. So I believe that number of judgments of the Supreme Court are right according to me, number are wrong according to me. So this judgment is a very important one where I think they have got it wrong. That the right to vote has to be a fundamental right. If not, democracy sort of becomes very weak and unstable. It's another thing that reasonable restrictions may be placed on the right to vote in certain situations. What they are, we don't know. We can debate that. But, and hopefully they'll be very, very limited and fully democratically justified and set. But I have no doubt in my mind that is a wrong judgment. So what do we do about it? When you become a judge of the Supreme Court, you should strike it down and say that the right to vote is a fundamental right. And persuade other judges to go along with that. You become a leading lawyer in the bar, which is even better. But then you should persuade members of the bar that we have to reverse this. So like ADM Jabalpur got reversed, this has to be reversed. There's also the right to contest. You remember there are a whole series of judgments that you don't have a right to contest. They're both mirrors of the same democratic right. We have a fundamental right to vote and a fundamental right to represent. And we have to exercise both. So I agree with you, basically. And that I think the Supreme Court is wrong and Krishna is right. Thank you.
So the DPSP question.
Okay, DPSP, very important question, yeah. DPSP, see, if you view the Constitution as a site of struggle, not only DPSP, but let me give you an example of even less enforceable and arguable normative propositions, which are laid out in numerable United Nations non-binding protocols and documents and instruments. They all give us a basis for fight. They're weapons in an argument. In law, our only weapon is an argument. Law only deals with words. There's nothing else except words. And the weapons are arguments. So these provisions give us a basis for arguing that the United Nations in this protocol on the rights of children or the rights of prisoners or rights of something else has laid this out in the General Assembly. So it gives us a basis to make that argument. Directive principles of state policy, because they were written, therefore, because they are not useless, it was premature to say that in the Constituent Assembly, because it is from there that we extracted the right to education, the right to environment, and so many other rights that were not really explicitly enumerated in the Constitution. So the value, if we understand that the Constitution is an integral part of and the site of a larger democratic struggle that is taking place not only in the courts and in the Constitution but everywhere in society on a day-to-day basis, then we understand that whatever argument we can get, imperfect as it is, to take us forward in these rights, normative democratic principles are very useful in the struggle. Then look at Vishaka judgment. See, ultimately the Supreme Court again relied on United Nations principles to lay out a proposition. Now, frankly, many of the Supreme Court's judgments are no more effective than DPSP. So, does it mean that those judgments are wrong? No, because ultimately this fight is between people, not between documents and books. It is between people. A bunch of people who believe that the others must be dehumanized, controlled, and exploited. And a bunch of people who don't want that to happen. It's between people. So those people, that fight can take place violently or it can take place non-violently using arguments as weapons. We prefer the latter. We don't want violence. So these DPSP and other provisions provide us valuable weapons through which we can, and I've had experience of that. When you approach someone and say, this is in the directive principles of state policy, it may or may not be binding, but this normative proposition is that they're extremely valuable. So in this process of persuading people, the moment we are able to persuade a critical mass of people in this country that democracy is valuable, authoritarianism will fail. They are not convinced about the value or importance of democracy. And I think many of these arguments will help us to convince people that democracy is valuable. The power must be in your hands. It matters that power is in your hands because it matters whose hands power lies in. We have to convince people. That's a real argument. It's not about winning or losing cases. It's a battle for the human mind. Yeah?
Thank you.
Thank you. Thank you very much for that excellent intervention. Yes.
Hello.
Yes, sir.
Good evening, sir.
Good evening.
My name is Yusuf. I'm currently in my second year PhD course.
Yes, sir.
Sir, B.R. Ambedkar in a speech windows on which the mercy petitions are decided
Yes.
directly undermines the constitutional right
Right.
to seek executive clemency. But executive clemency is not a constitutional right, as Article 72 and 161 gives pardoning powers and discretion to President and governors.
Yes.
And it's only through the case law Shatru Singh Chauhan versus Union of India,
Yes.
where it was set within a constitutional standard, but didn't give a deadline. And you went on to write that Supreme Court contends that if all the required documents are submitted before the president, we have to assume that he has applied his mind in deciding or rejecting mercy petitions, however short the time frame within which he decides. Ex-President Ramnath Kovind took 272 days to decide consider and reject mercy petitions in his first mercy petitions that came before him. But he gave a mandatory deliberation period for the president and governors to decide diligently on how the mercy petition should be dealt with. That's my question.
It's a very good question. As you know, I am very strongly against capital punishment. And like most countries in the world, there are very few countries that still actually allow or implement capital punishment, and so I'm against that. So naturally, if there's a clemency petition, my own preference is it should be allowed. If it's not allowed, then let it be delayed as much as possible. Because if it's rejected and somebody is killed, that's the worst outcome, right? So I would not want to put a time limit on it which will ensure that somebody is executed quickly. Right? Now, on clemency petitions, there's a lot of good literature on that, and I think that everyone has the. I think there's no question that everyone has the right to seek clemency, because the power exists and you have the right to seek it. You don't have the power to get it, but you have the power to seek it. And if it's sought, it must be considered very, very gravely by everyone concerned, because you are inflicting the ultimate punishment, taking away someone's life irreversibly, right? And so I would say that we need the Supreme Court to certainly provide more guidance about how clemency petitions are evaluated, what the standard should be, and give evidence of what the president thought, how he applied his mind. Maybe the president should be asked to give a reasoned decision on why he is accepting or not accepting. We have someone like President Kalam, who I think accepted, or did not reject any mercy petition that he got. If I'm right, I'm not rejected, but that's my impression. I know he was very concerned about the death penalty, and he once asked in my presence in a meeting after he retired, why is it that the judiciary gives the death sentences only to poor people? Because he said, I've only received clemency petitions from very poor people. Not that others want to die, but I've only received petitions. So he was very concerned about it. With him, I have no doubt that he has applied his mind. I would assume that President Kovind also must have applied his mind. I doubt whether any president would reject a clemency petition without applying. I can't take it for granted, but my assumption would be that once one human being deciding to kill another human being, not directly to kill, but to allow the killing of another human being, and he would apply, or she would apply his mind. But I think, yes, there is room for the Supreme Court to provide greater detailed guidance on how clemency petitions should be considered. But even more importantly, I think, including if we look at Madan Lokur's judgments and Justice S.P. Sinha's judgments, you'll find a lot of basis to say that the Supreme Court must declare a moratorium on all death penalties. Because these two judges have written extensive judgments which have shown that the death sentence is currently being handed out in quite an arbitrary manner, an unpredictable manner. And nothing can be done in an arbitrary manner. So till we are able to ensure that death penalty meets with Article 14, forget 21, requirements of non-arbitrariness, I think personally I think that the Supreme Court should place a moratorium on the death sentence until we sort all this out. I think one more question.
This is Radha from second year ELLB.
Yes.
So my question is regarding the. I'll frame up my question with the help of an example. So the 130th Constitution Amendment Bill. So it states that Prime Minister or Member of Parliament and Member of State Legislative Assembly, Chief Minister, will get automatically disqualified if they are held in custody for 30 days with a crime which should have punishment for more than 5 years. They will be automatically get disqualified. So I observed the parliamentary debates regarding this. It's a bill. So in the debate, it has not. They laid emphasis on corruption, on one party dominance, but there have been no emphasis laid down on the federalism, or because this and also there is no clause mentioned in this particular bill which talks about state ratification. So also, sir, according to Article 368, it has been mentioned in the state ratification clause on what conditions there will be the requirement of state ratification. But sir, it is somehow impacting the federalism, which is the basic structure of a constitution. But sir, Article 368 explicitly does not mention about it. So sir, my question is that there is a contradiction between in the constitution itself, that there is no clause explicitly which protects the basic structure, but there is a violation of basic structure happening. So this inconsistent. How should how should we deal with as a jurist, what is your opinion and comments about in this situation in which there is a contradiction in the constitution itself, and how should be dealt?
In US jurisprudence, there is something called a political question. Political question. And the courts are not supposed to decide political questions. It's simply to avoid political questions being, courts being used to decide political questions. So there are many such examples in our country where a bench of 5 or 6 judges decide a very complex political question, whereas if it had to go to Parliament, then you would have had 274 or 280 or 540, majority of 543 Lok Sabha MPs have to be mobilized to support it. You give it to the judiciary and you can have 2 or 3 people or 5 people or 6 people decide the issue. So the first question, this is a political, I think may have risen out of the Kejriwal situation, this whole proposal. That Kejriwal was in jail and he was functioning as a chief minister from jail. That created all kinds of issues, and it may have come from there. I'm not saying it did, but could have. And so it's ultimately a political question. It does affect democracy, to my mind, more than federalism, for reasons I'll explain. But democracy, in the sense of it is, you can use a criminal prosecution to remove a political official whose election is political. You remove him from political office. And that's not correct. So if I were in the Supreme Court, I would say this is a political question. And to some extent, if the requisite majority in Parliament has approved it, then we have Rajya Sabha also, which represents the states. Why is it not a federal question? Because we have a unitary criminal law system in our country, unlike in the United States where they have state, federal criminal law and state criminal law. We have one criminal law for the whole country. And therefore, all states and the union have the right to go before a judicial forum, which is another branch of government, and in the appropriate level, and charge somebody with a crime, and then that process will decide whether he is to be jailed or not to be jailed. And so it's hard to say that this is something where, suppose someone has committed a crime, what should the consequences be in terms of holding political office? But the point you're making is whether that should lead to the removal of a chief minister is a matter that states should respond. So states should challenge this in Parliament, and we could argue that if the removal of a chief minister is to be included in this bill, then it must be subject to the approval of the minimum number of states, as is provided for in some constitutional amendments. So there are mechanisms for that as we go forward. But the crime itself is not in that. There's no federal issue there. But the consequence of removal of a chief minister, I agree with you, is a matter that should be considered by the state governments for their own state, not necessarily one position for the whole country. Or it should be put into Parliament according to the processes of amendment that require the approval of all states, although Rajya Sabha is still there. But they are not they are drawn from states, but they are not acting for the state governments. But separate from all this, I think it creates an incentive to charge people who are in political office and remove them. So maybe it should be restricted to very narrow crimes, such as extreme crimes. I don't want to give examples, but narrow set of crimes, rather than simply say anything over 5 years or 7 years. Because if you have peanuts in a public place, then you have 7 years of imprisonment. You catch a guy having peanuts for 7 years and you arrest him and put him in jail. And then he's chief minister, he loses his office, or prime minister, you throw him out of office. That's not fair. So I think the bill needs a lot more public debate and to ensure that it does not reduce our democratic rights. Thank you very much. I think we must stop here.
And the graduate of 2024 batch, sir.
We're practicing where, sir?
High Court of Andhra Pradesh.
Which bench? Where?
In Amara.
Andhra Pradesh. In Amara. There's only one bench.
2024 batch.
There's only one bench.
One bench, sir.
Yeah.
I'm a 2024 graduate of this university.
Yeah.
My question is short is that with due respect to the system I am working in, so for appointing a peon or as office subordinate in judiciary, there will be mains, prelims or interview. Whereas coming to higher judiciary, there is no such. Judges are appointing judges, and which is highly criticized by today's community and the youth. What's your opinion on this collegial system, judges appointing judges? Sir, and what would be the best solution? Did the constitution give that power to the judges to appoint judges, or what is the situation in other countries? What is the best solution?
For a long time is, first of all, it is not as simple as saying judges are appointing judges. It's not so simple. I think all along, judges were appointed by consensus between the political leadership and the judicial leadership. That was the approach. At some point of time, the executive started to become very partisan and the committed judiciary and so on and so forth. And there was an attempt on the part of the executive to select who will be judges, and that was a threat to the independence of the judiciary. So then we had the judges' cases, the third judge's case that said, look, the Constitution does say that the views of the Supreme Court, the Chief Justice shall be consulted. Right? And they say, and I agree with that, when the Chief Justice is consulted and the Chief Justice says that I don't suggest this person, then it's better to find someone that both sides agree with, rather than inflict someone on the judiciary that the Chief Justice feels is unsuitable to be a judge. So then the collegium mechanism evolved went further and said, okay, only the judiciary will respond, not appoint, will only respond, and then the executive has a chance to object. They can also suggest names to the collegium, but they can't recommend for appointment. The collegium will consider. The formal recommendation will come from the collegium. They can object. The government can object. But if it is reiterated, government has to appoint, so that there is an end to the process. But it's up to the government to show what the basis of their objection is. Now, the problem here is lack of transparency. And there was a period where, I think when Justice Deepak Mishra was Chief Justice for a period of time, all the correspondence was made public. And there was some judge in relation to whom the government said that he was associated with some criminal act, lawyers representing criminal act, all kinds of things. We could see all that. So when the transparency is there, we understand the recommendation of the judges to the collegium, the collegium to the government. We understand the justification for that. We understand the nature of the objection. And in a democracy that is not consistently or that is problematic, soon huge opposition will emerge to that system. Because they say, look, there is no basis for who you're recommending and appointing and so on. And so the way forward, I think, is to make it completely transparent, that all correspondence must be made public, the appointing of a public official. The second thing is they must clarify the criteria. What are the criteria on which a judge must be appointed? The third is they must ensure representation. As I said, judges come from a very narrow set of social backgrounds, family backgrounds, chambers, professional experience. There's inadequate representation of various groups of people, communities, gender, and so on. So there's a lot of problem with representation. And there's also a question of whether actually the most suitable persons are being selected or not. So there should be a wider process. So I think, for example, there should be a process where people can apply. I think I'm a very good judge, I'll make a very good judge, and I want to apply. And they can reject it, if they want. But and so if you compare all these things, then I think we can transition to a better system. What I'm afraid of is in a country where there is a strong difference of opinion between certain political groups and the constitution about whether there should be an independent judiciary at all, right? To hand over power to the executive branch may actually result in judges being appointed who are not sworn to, who cannot be, by their public statements before they became a judge, seem to be true to their oath of upholding the Constitution. And the politicization of the process will increase rather than decrease. So I think and also if the collegium can involve some independent, like when you remove a judge, you've got a 3-person panel. A Chief Justice, sitting Supreme Court judge, a Chief Justice, sitting Chief Justice of a High Court, and a distinguished jurist. There have been only 5 or 6 such panels. I was a member of one of them actually, so I have personal experience of that. So in these circumstances, why not have in the collegium whoever the judges wish, some independent voice from the bar or from legal academia or both, legal academia, serving professors or leading lawyers, so that there's a wider opinion within the collegium that is not simply a question of judges. But I would rather, at this point of time, this is not a permanent solution, I would rather trust the collegium than allow politicization by handing over to the executive branch, by strengthening the nature, the criteria, the transparency, all these aspects, and bringing back the confidence of the people that the judiciary can do a good job of ensuring that the right people are appointed to the judges and the system will work in a competent and responsible manner. I think that may be, in my own view, that may be a better way to go. And the National Judicial Appointments Commission was not quite doing that, and didn't get inspire the confidence of the judiciary. But we should take the judges along and the public along. And the public want accountability and transparency. They don't care who appoints. They want good people, honest people, competent people to be appointed as judges, and that's very much possible. All of you are here. Many future judges are sitting here in this room. I'm sure you'll make wonderful judges. But it's again a very complex issue that we should move forward. But we should not say judges appointing judges. This is what columnists say. But it's not as simple as that. It's not as simple as that. Okay, so if I don't go now, Vice-Chancellor is going to be upset with me. So and I must say I enjoyed the brief intervention of the Vice-Chancellor on Ambedkar and his role and all that. He's a very erudite Vice-Chancellor, and I want to express my appreciation for his comments, and also for giving me this, allowing me to inflict myself on all of you and listen to your wonderful questions and answer you. Thank you so much.
I would like to invite respected registrars to the stage.
Good evening, all. Good evening, sir. Thank you, sir, for accepting the invitation to interact with the graduates. On behalf of DSNLU, our students, we thank you, sir, for accepting the invitation. Thank you, sir.